with Amy Coney Barrett. It's not Trump's critics who want to create a permanent independent counsel. They may soon regret that, and I would expect them to drop this proposal now that Joe Biden has won. But I think an independent counsel is one of the greatest threats to the structural independence of the presidency by creating a species of law enforcement outside the control of the president. It's not Trump's critics who want to nationalize the energy industry, large parts of the transportation and housing industries with this Green New Deal that they propose. And so let me just say that what Trump has been doing with presidential power has been very, I think, really to use it as a shield. The two great crises of his presidency were, of course, the Russia collusion investigation and impeachment. In both cases, Trump really resorted to the inherent powers of the president. One, to oversee the enforcement of the law. Two, to conduct the foreign policy of the nation, really to fight against, I think of this as the 20th century progressive vision of the Constitution, to fight against an idea of government which vested large parts of the executive power in independent bureaucracies. And this idea, which I think traces its origin in American constitutional politics to Woodrow Wilson, the idea of this was that public policy questions were too important for politics. They should be handed over to experts, and those experts should be insulated and protected from politics. And so, whereas Trump, I think, by claiming the right to lead law enforcement, the right to conduct foreign policy, was trying to return back to the original 18th century vision of the Constitution, where we elect a few officers and they're directly responsible and accountable for the public policy issues and decisions of our government. So think about the collusion investigation. Here you have a case where the firing of Jim Comey, the head of the FBI, sparks this constitutional basis. But I would say that was completely within President Trump's constitutional authority. And then fighting with Robert Mueller. And, Robert Mueller and Jim Comey, both sort of the paragons of professionalized, expert law enforcement, prosecution. But yet President Trump's fighting to place both of them under his constitutional control. I think whereas they are, and you read the arguments about them, are demanding the independence of a part of the executive branch from political control in order to claim the right, claim the mantle of professional expertise. Same thing with impeachment. There you have another bureaucracy, the Foreign Service, trying to rise up and claim the ability to set the national foreign policy goals. Remember, you hear all the time about the exalted interagency process. How could President Trump be at odds with the interagency process? And then the idea that the Foreign Service was somewhat independent, the national security staff are independent really of presidential control. And again, against a president who without a doubt had unorthodox foreign policy goals, certainly unorthodox methods for advancing them, but those are the powers he has under the Constitution. So sorry for my technically primitive. You probably guessed I'm probably now bicycling on a machine that I've now hooked up to my phone to generate enough energy. I get the feeling this is going to be more and more the case in California, whereas more and more of my compatriots are starting to move to Texas, where the lights come on when you flip the switch and you're allowed to drive from one place to another. So thank you very much, and I look forward, I hope, to Sai's comments. I look forward to be able to keep participating as long as the electricity supply allows me to out here, and hearing your questions and giving you some answers. Thank you very much.
Well, great. It's great to be here with the Texas chapter. I will say, hook 'em horns. I like your logo. You just need a bolo tie and add that to James Madison's bust there, and you're all set. And it's great here to be with my good friend, John Yoo. John Yoo, in this sort of avatar, kind of comes across as the Wizard of Oz. You can hear his voice and you can sense that there's a power there, but you can't see him. It's kind of mysterious, but it's great to be with him. I've got John's book right here, Defender in Chief. John can't flack it, but I will. Get a copy of this book. It's a great stocking stuffer. And there's a photograph of the president on the cover. If you go on the web, you'll see that John met the president in the Oval Office, and they both smiled while John held the book. This is my book, The Living Presidency. It's about what the presidency has become. It's not really about Trump at all. In fact, it says very little about him. It's about what the office has become over the course of 200 years. And my claim isn't, again, Trump specific. The claim is that we have, in fact, a living presidency, just like we have a living constitution, in the sense that our practices reflect differences in conceptions, differences in understanding from the founding. What do I mean by that? Well, if you go back to the founding, you see a powerful office, you see a president who's in charge of law execution, who has some foreign affairs authorities, who can make treaties with the Senate's consent, and his commander-in-chief has some share of the legislative authority by virtue of the veto and can direct the bureaucracy. But the president can't make treaties without the Senate's consent. The president can't declare or wage war. And the president has to faithfully execute the laws rather than pervert and twist them. If you flash forward 2 centuries, I think these features of the original Constitution have been left in tatters. With respect to war powers, John and I disagree. My claim is that the power to declare war is the power to decide to wage it. Granting that authority to Congress meant that the president couldn't wage war on his own authority. When the president wages war on his own authority, he is in fact declaring it. With respect to treaties, you may or may not know this, but we hardly ever make treaties anymore pursuant to Article 2. How do we avoid making treaties thus? How do we make treaties by other means? Well, the president makes so-called sole executive agreements that are, in some cases, treaties by another name, and he doesn't present them to the Senate because he, along with his lawyers, believe he can make them unilaterally. But perhaps more importantly, the president now makes treaties overseas and submits them to Congress for majority vote, right? Think of NAFTA, think of the USMCA. These are treaties, but they don't follow the Constitution's 2/3 requirements. Instead, the president just gets a majority of the House and Senate to agree. And this is effectively a bypass of the treaty clause, right? It's a secondary way to make treaties. It's totally, in my view, unconstitutional. It didn't exist until the 20th century. And it's just a way for presidents to make treaties without satisfying the textual requirements of Article 2. It is far easier to sometimes get a majority in both chambers than it is to get 2/3 in the Senate. And so the way to think about it is the president has 2 options or 3 options to make a treaty. He can follow Article 2, he can use the congressional executive agreement track, or he could try to argue that he has authority to make a sole executive agreement. And then finally, with respect to law execution, I don't think the president principally conceives him or herself as a law executor anymore. They no longer think of themselves as executives. They think of themselves as policy innovators. They run on a platform of policy innovation. They're going to change this and change that, give you health care, modify your health care, give you a tax cut, raise your taxes. They're not running on making the trains run on time. They're not running on efficient administration of the law. They're running on changing the law. And that has a corrosive effect on what presidents do once they're in office, right? That and the fact that Congress has delegated tremendous amounts of legislative power to the president. So when you run on a legislative platform and you have tremendous legislative power courtesy of your supposed rival Congress, you naturally conceive of yourself as a policy innovator and a policy changer. And that's how we see presidents repeatedly making up law as they go along, or evading or minimizing law as they go along. So let me give you some examples. The auto bailout in 2008, well before your time as students, but as you may recall, we had a financial crisis in 2008. Congress passed a statute authorizing a bailout of financial institutions. President Bush decided that he should bail out the automobile manufacturers anyway. There was no statute either authorizing or appropriating money for this. But Bush did it anyway. And he did it in the face of a congressional unwillingness to pass an auto bailout. The House had passed an auto bailout, the Senate had not, and Bush said, I'm going to do it anyway. And Barack Obama continued this. This is a sort of an obvious violation of the Constitution because presidents can't withdraw money from the Treasury unless there's an appropriation. There was no appropriation for this. But he did it because he sensibly understood that he would be blamed for GM and Chrysler's collapse. He didn't want that to happen. He also didn't want there to be the misery that would come from the collapse of those two companies. And Barack Obama made the same calculus. I submit to you, if this crisis or something like it had existed 100 or 200 years ago, there's no way the president would have just spent the money in the face of no appropriation from Congress. Let me give you another example. There's the Obama administration's approach to the ACA and insurance company subsidies. The ACA authorized the executive branch to subsidize insurance companies in order to make their premiums for newly insured people more affordable, right? If you subsidize them, they can charge less for adding new people to their insurance rolls. So the ACA authorized this, but it did not appropriate funds for it. It said you could do it, but didn't give the funds. And the Obama administration went to the Congress and said, okay, well, we need money now for this program. And the Republican Congress said, no way, we don't want any connection to your awful program. And so they didn't give him the appropriation, but what did Obama do? He just said, well, I'm just going to spend the money anyway. I'm going to reinterpret the ACA so that not only does it authorize, it also appropriates as well. This too was a silly argument. It was silly in part because the Obama administration had previously admitted that there was no appropriation, and now they were doing a 180-degree turn from that point of view when convenience suited. So that's another example of presidents misinterpreting statutes. Let me give you a third example from this administration, the wall. President Trump promised a big, beautiful wall and promised that Mexico would pay for it. Of course, Mexico never did pay for it. They didn't get the memo. He went to Congress and asked for money. The Republican Congress would not give him any money for his wall. He did not get money for 2 years. He finally got $1.5 billion out of all people, Nancy Pelosi. And he negotiated hard to get that $1.5 billion. He wanted more, but he couldn't get it. But what did he do to get more money? He declared an emergency, diverted funds from the Treasury, from the Department of Defense, and then built the wall, built a bigger wall than Congress had appropriated for. Now, there is a statute that authorizes the president to transfer funds on the declaration of an emergency. And so there is statutory authority for declaring emergencies and transferring funds from the DoD. The problem is there wasn't an emergency, right? There was nothing like an emergency. He transferred money for the wall the same day he got $1.5 billion. And so it boggles the mind to think that there was an emergency on that day that didn't exist the day before when he was negotiating with Congress. What essentially happened was he wanted more money. He was unsatisfied with what he got, and he hit upon the expedient of declaring an emergency. This was a faux emergency. No one thinks there was a new situation that arose on the border the same day that he got his $1.5 billion. Now, I criticize him for this. John defends him. I criticize him for this, but he's clearly not alone. Other presidents have declared faux emergencies. There's dozens of faux emergencies right now that presidents declare from year to year. Some of these emergencies have lasted 30 or 40 or 50 years. And that's because Congress has granted the authority to do something, to exercise some discretion if the president declares an emergency. And presidents find it expedient to declare an emergency. They're essentially reading these statutes as if they said the following: whenever the president finds it useful or appropriate to take some action, he can. And that way of understanding emergency, I think, is inconsistent with other statutes that actually give the president that authority. That is to say, if you find some set of statutes that say the president can take some action whenever he finds it convenient, and another set of statutes that requires an emergency declaration, I think you can fairly assume that the latter set of statutes should not be read as if they were the first set of statutes, right? To say that there has to be an emergency, I think, is to imply that the president has to honestly believe that there's an emergency And there's no way that President Trump did that or believed that. Why have we gotten to the state where the presidency has expanded over time? Why do we have a living imperial presidency? It's a reflection of a number of factors. Let me cite a couple of them. First, we have outsized expectations of our presidents. We expect them to prevent us from getting sick. We expect them to build livable communities. We expect them to defend our nation. We expect them to keep our air safe. We expect everything of our presidents, right? There are tremendous expectations on the shoulders of our presidents because we expect them to solve all of our problems, mental health, what have you. We expect them to solve it. But the reality is we don't give them all the legal wherewithal to satisfy those expectations, right? We still have a system where Congress makes laws. We don't have a system where the president, as a formal matter, can make all manner of laws. What that does, though, is it puts pressure on the president to find or manufacture legal authority in order to satisfy those expectations. And that explains the auto bailout. I think it explains the ACA insurance company bailout. The wall is partially explained by the president's need to satisfy his promise to his base in the American electorate. He ran on building a wall. It was embarrassing, deeply embarrassing, that the Republican Congress wouldn't give him funds. And I guess he thought it wasn't the funds he got from Nancy Pelosi were insufficient. So he had this promise and he desperately felt he had to satisfy it. And so he hit upon this expedient. So the practice of making promises, I think, has a corruptive effect on the president because presidents feel the need to satisfy them. I think it's quite clear that Congress as an institution has proven incapable of checking the president. The founders thought that the branches would counteract each other via their ambitions, their political ambitions. But in fact, many of the policy ambitions of members of Congress are satisfied by permitting presidents to aggrandize their office, right? If you're a Republican, you have a Republican president, you're not worried when the Republican president seizes extra authorities to advance the Republican agenda. And the same is true for Democrats in Congress. They are not going to squawk when Joe Biden seizes powers to advance his party's agenda. And so what I'm trying to say is that basically 30, 40, 50, 60% of Congress favors presidential aggrandizement when that aggrandizement serves the party's policy platform. And that effectively means that Congress is on the sideline of many separation of powers disputes because you can't effectively check the president when 40 or 50 or 60% of Congress is cheering them on. Let me mention one final thing, and I look forward to your questions, so please send them in. The one final change in our conception of the Constitution, of course, is the whole idea of a living Constitution, right? Today, as you know from constitutional law, we have this notion that the Constitution's meaning can change without any formal amendment to the text. And we've seen this with respect to the Commerce Clause. Congress exercises far greater authority over our nation by virtue of a ridiculously expansive understanding of the Commerce Clause, a view that was basically foisted upon the American people in the New Deal. As Roosevelt said, why should we be tethered to a horse and buggy conception of the Commerce Clause? And the courts themselves have participated in the ongoing living Constitution experiment by revising our rights in the Constitution to expand others beyond the text and to limit others, to basically read out of the text certain rights, like say the Contracts Clause. So if you have a court that is basically tethered to a living rights conception under the Constitution, and you have a Congress that believes in a living Congress, why would we expect the presidency to be any different? Why would we expect the presidency to be tethered to a quill and canon conception of Article 2 powers? The president's just like everybody else. If he can see other people exercising powers not attributable to a fair reading of the Constitution, he or she is going to do the exact same thing. And that's exactly what we've had. And so one of the principal arguments in the book is addressed to progressives. If you favor a living constitution with respect to rights and with respect to the scope of congressional power, how is it that you can complain that the presidency has gone beyond the scope of the original presidency? It's a bit inconsistent, to say the least, to say, oh, the presidency has gotten too big for its britches, too big for its spurs, but Congress and the courts can modify the Constitution at will. So again, I would encourage you to get a copy of both of these books. They're great. If I say so myself, they complement each other because one is really about Trump and one is not. One is about all the controversies that have surfaced during his administration, and John ably discusses those. And one is about what our presidency has become and will be under the Biden administration. A lot of the stuff I talk about will be highly relevant for those who wish to criticize the Biden administration. And with that, I welcome your questions.
Yeah, thank you both so much for those remarks. We're going to go ahead and jump into the Q&A, and we have a couple questions loaded up in our chat. So this one wants to know if when the president makes a factual determination, for example, that an emergency exists, what kind of standard do you think the courts should use in evaluating the president's judgment? Should the courts be deferential, or should they apply a standard that has, quote unquote, more bite? And I think this one is for both speakers.
So Kylie, let me because I've had to listen to Cy speak for 15 minutes without being interrupted, which it's very hard for me to do. I don't know why all of you are letting him go on like this. We should jumping him and attacking him immediately. So I think actually much of what people disliked about the Trump administration, it was not actually his constitutional power, but actually the subject of this question, well, delegated powers. So think about the travel ban. I think about the wall. These were not actual claims that the president made on his constitutional authority. Although I think it's interesting, there could have been claims on constitutional authority. Instead, he made arguments based on delegated statutes, as the question suggests, claiming there's a national emergency, and then triggering the powers given to him by Congress with the travel ban. The immigration laws clearly say the president can, based on national security purposes, block the movement of people in and out of the United States to another country or from another country. In fact, nobody complained about this when President Trump blocked travel from China in the course of the coronavirus epidemic. Played a ban on travel with other parts of the world. The border wall, President again, statute says if the president declares an emergency, the president can move money between military construction accounts. And I can't think of something that's more based on military construction than building a wall along the border. I mean, it used to be the purpose of the armed forces to protect the sovereign territory of the United States, and a border wall certainly can play a role in that by reducing the need for actual troops along the border. So the question is, it's a great question because, well, what for declaring a national emergency is for powers for the president? Well, I don't think it's the president's if Congress doesn't place any definitions or standards on what a national emergency is. The National Emergencies Act passed in 77, 78.
I think, John, we lost John there for a second. So I've heard John discuss this, and I'll finish his thought for him, and maybe he'll join us again. The statute that Trump invoked with respect to the DOD and the National Emergencies Act itself doesn't define emergency. And I think John's further point is, since it doesn't, it's up to the president to define what it is. And then further, I think John's position is the courts shouldn't really be second guessing any of this. And because, it's really just the president's opinion as to whether or not there's an emergency. And so his point is, if Congress doesn't define it, of course, the president's going to have to decide for him or herself what an emergency is and then make decisions on that basis. I think I've accurately summarized what John would have said, and maybe he'll join us in a second. But I'll give you my response to Austin's question while we wait. And so I think this is a great question, Austin. There are two aspects to it. And I think one question is, well, what does it mean for there to be an emergency? And the second question, which is what you're focused on, is can the courts review it? John, are you with us again?
Yes, sorry, I think I stopped biking for a second and my phone gave out, but I was finished anyway. Go ahead, Si.
So I think there's two questions here. One is what is an emergency, and two, can the courts get involved? And I want to make it clear, my view about emergency is my view independent of whether the courts can get involved. I'm not saying the courts, that this is judicially reviewable. I'm not saying it's not. I think it really would depend on the statute, whether it's judicially reviewable or not, and what standard review there ought to exist. John's absolutely right that there's no statutory definition of emergency, but I don't think that implies that the president can just say, that anything is an emergency, right? If his reason for there being an emergency is that it's Monday, that clearly would be silly, right? And no one would say, oh, that's an emergency because the president said it was an emergency. Because when you interrogate him, he admits it's an emergency because it's Monday. So I think more is required of the president than to just use the magic word. It's not Aladdin's cave that if you just say the word emergency, you're golden. I think you actually have to believe it. And again, I would draw a distinction between these statutes that require some declaration of emergency and other statutes that don't, right? Again, go back to McCulloch versus Maryland, which I assume you've read in con law. Marshall says there's a difference between necessity and absolute necessity. And he's saying this in the context of a constitution that uses necessary and proper versus absolutely necessary, right? In the context of state tariffs on goods. And he's saying these two things, they're two different standards, right? One is merely useful, necessary, and one's a higher standard, absolutely necessary. So you can go back and look at his opinion and then look at the Constitution and see that he's right about this. And that's my point about emergency statutes, that they don't merely just turn on the incantation of words. You have to actually believe it, A, and B, I think there's got to be some reasonable belief that there's an emergency. And then the last thing I'll say about statutory authority versus constitutional authority. This is a claim that was often made, ironically, by the Obama administration. They would often say, well, we're not relying upon constitutional authority. We're relying on statutory authority. And the devil's in the details, right? The question really is this a plausible interpretation of a statute? Is what you are suggesting a plausible interpretation of the statute? Because in the extreme, if it's not, then you are making a quasi-constitutional claim, right? So when the Bush and Obama administration used funds explicitly tied for financial institutions to bail out the automobile manufacturers, they are using a statute, but they're so wildly misconstruing it that it's a fake argument to say that you had permission from Congress, right? It would be like a kid saying, I got permission to go to the store, therefore I can go to Disneyland. You did have permission, but not to go to Disneyland, right? And you could say there's statutory authority, but not to do what you did. And when you make misinterpret a statute so badly, it beggars belief that you're really making a statutory claim. You're basically making a faux statutory claim in order to avoid the constitutional claim, or just to achieve a policy results. I will say this: expect the Biden administration to do the exact same thing, right? To do what the Obama administration did, what the Bush administration did, and the Trump administration did, to try to rely on phony or fake or false statutory arguments to avoid having to claim constitutional authority, right? To say, well, I'm not using the Constitution. This is all Congress. Congress gave me the authority, and now they're to be blamed if I use it because they grant me the authority.
I think before we jump to Henry's question, we have another question, and this one is actually directed for you again, Professor Prakash. So which specific so-called presidential power grabs that occurred under the Trump administration do you foresee will be used or abused by the incoming administration?
I'd like to hear what John says as well, but my understanding is that the Trump administration has been somewhat aggressive in trying to provide relief to individuals provide relief to individuals during the COVID crisis. There was a impasse with congressional Democrats, and the Democrats wanted, more trillions of dollars than Trump wanted or than the Republicans wanted. They couldn't pass the second a COVID relief bill. And so the Trump administration kicked into high gear and found a bunch of statutes that they read as authorizing COVID relief of various ways. And there were probably libertarians and some Republicans who opposed this. But in the main, they said very little because, the president was, acting on behalf of Republicans in some sense, and certainly was the Republican standard bearer. I wouldn't at all be surprised if the Biden administration also read these statutes aggressively to give Biden unilateral authority to take various measures. I think what Trump did is he provided some sort of tax holiday for a year, thinking that if he couldn't get tax relief through Congress, he would basically allow people to file their taxes late. The expectation is, Congress will actually change the statute so you won't have to face a tax liability next year. That puts pressure on Congress, of course, to provide that tax liability. There was stuff about mortgage relief as well, using whatever authority I think maybe the Treasury or Fannie or Freddie Mac have with respect to mortgages. So there's a couple of things that the Biden administration might try to do with respect to COVID when they find that Mitch McConnell isn't as forthcoming.
I just sense here. First of all, I think we since when I look at the border wall example or the travel ban example, those would fall within the range of what's been considered a national emergency in the past. And courts have never shown the least desire to try to second guess what's a national emergency. But if it's what would the Biden administration do? So I think the thing to be worried about, I don't think would be things like border wall or the travel ban national emergencies, which were, I think, response to discrete events and changes in circumstances that were sudden. But what I would be concerned about would be if the Biden administration were to say climate change is a national emergency. Something that's a much broader, gradual, slow change in circumstances, which may not fit, I think, our definition of what's an emergency. On the other hand, I really don't think the courts would even second guess a declaration by the Biden administration that climate change is a national emergency. That the courts would expect Congress to take any necessary steps to fight back.
And I think that kind of leads into Henry's question and a question that I have for both of you. And I know you both have touched on COVID measures, but just out of curiosity, what should we expect from a Biden administration with regard to, a federal mask mandate or a national lockdown? And then Henry also is asking about, a hypothetical administration ban on assault weapons by executive order. So what do we think those types of executive orders would look like with respect to, appropriate executive authority?
Oh, this is interesting because I think this is another good example where Trump's critics were the ones who I think were calling for measures that are beyond the Constitution, and Trump actually stayed within his constitutional authority. I think the response to the pandemic is displays that. So think about the pandemic. Trump, I think, federal government in performing the traditional federal function on an issue, even public health and safety, I think is a subject that's reserved to the states and the police power. The federal government doesn't have a direct role in public health. Instead, it has to use the Commerce Clause, the Spending Clause, Acting Clause. Does that apply sources like personal equipment and regulated interstate travel and international travel? A lot of money, as it had the constitutional right to trying to get a vaccine developed quickly. It supplied enormous amounts of money to the states and to individuals. But what Trump couldn't do was to shut the country down or to open up. I think those still rest within the powers to do that in the state. And much to a political detriment. I mean, I think what the polls are showing from the election is that coronavirus was the number two in the campaign and the election, and that for people for whom it was the most important issue, I think they voted for Trump by something like that. I'm sorry, for Biden by something like 70%, enormous margin. If Biden comes in and he wants to say everyone in the country has to wear a mask, I think under Obamacare, that would be an unconstitutional exercise of the common laws. Now, Congress could buy everybody in the country a lot of masks and give them out. Could create tax incentives to, align conduct with federal priorities, and could get guidelines about what states should do, and they could coordinate information. But I think even in this situation, the federal government has the authority to open or close all the businesses and establishments in the country, to tell churches they can and can't meet, and to force everybody to wear a mask.
I agree with much of what John said. The president can go on TV. Anyone can go on TV and say everybody has to wear a mask now. I could say it right now. The question would be what would happen if you chose not to wear a mask, right? In response to my order that you wear one. And I don't think that President Biden is going to claim that he can put you in jail or fine you for not wearing a mask. And so, given that, I don't really know what it would mean for the president to have a national mask mandate in that sense. If you go back to August of this year, the president issued a bunch of executive orders about mortgage relief or renter relief and tax relief and unemployment relief. And he did that because he wasn't getting what he wanted from Congress. He wanted to be perceived as taking action. I think he wanted to provide a stimulus to the economy. And if you go back and read the articles, you'll see that members of the Democratic Party criticized him, saying that the relief was weak, A, and B, unconstitutional. And I suspect that if Mitch McConnell doesn't give Biden what he wants, Biden will be tempted to do something similar to what Trump did, to try to do administratively that which he can't do through Congress. And we've seen this several times over the past several administrations, right? Obama can't get immigration reform, so he just bypasses it. I've given you the example of the insurance company subsidies. There's a bunch of these examples where presidents try to work with Congress if they don't get what they want. They then cast about statutes and regulations and try to accomplish what they want. As far as the assault weapons bans go, I don't know enough about the federal laws to comment on it, but I can guarantee you that they're going to try to do something like this, right? Because that's their ideology. They're not going to be able to pass it through Congress, so of course they're going to try something administrative. Whether they succeed or not, or whether their lawyers bless the attempt is uncertain, but of course they're going to try.
We have one more question for you guys. This one's from Tanner Baird. So he wants to know, is there any recourse against a president knowingly acting outside of their constitutional power if the electorate expects that type of behavior? For example, when George Bush signed the No Child Left Behind Act under the belief that the bill was unconstitutional.
I think it's a great question. I think this is one of the problems of the period we're living in. And actually, even though Simon and I are original and we disagree about the scope of presidential power, mostly because I was plain wrong, but we agree on a lot of other stuff. And we've written a piece together, which I highly recommend, that attacks this idea of judicial supremacy. And so even though we're talking about how far the president's powers have gone, and Cy thinks they've gone too far, one area I think Cy and I would probably agree where presidents have ceded too much power has been to the courts. The question is quite right. The president, and both of Cy and I were serving Bush administration when things were going on, which the president would sign legislation, and then he would say, well, I think these parts of the bill are unconstitutional. And I would even, not just the Left-Behind Act, I would suggest the McCain-Feingold campaign bill, which I think parts of it were just flatly, clearly, obviously unconstitutional violations of speech. I'm not even talking about like limitations on campaign contributions, but bans on running political ads with certain days of the campaign. And the president's, I think that's inconsistent, I think, with the original design. Presidents have the responsibility to take out a law executed. And peace, I argue that part of the laws is, in fact, the primary part of the laws is the consequence that presidents should enforce unconstitutional laws, and that instead, in doing that, they have to interpret the Constitution and make up their own about what the laws are unconstitutional. And so instead, you see presidents deferring to courts about what's constitutional or unconstitutional. And I think the independent and coordinate and interprets the Constitution in the course of doing that, and no one branch is superior other than that.
So just very quickly, I think Tanner's got a great question here. And I think, of course, there are recourses, right? So you're right that if the electorate wants something, presidents often try to gratify those wishes. But, I think as John just discussed, the courts are still out there as a check. So for instance, if Joe Biden wants to just send me to jail without a trial, I'm going to file, for a petition. I'm going to petition for a writ of habeas corpus, and the courts are going to release me, right? And it doesn't really matter that all of you might want me in jail. And so the courts are supposed to apply the law irrespective of popular preferences of whatever sort. So that's a check. What's changed, Tanner, is that Congress is less willing to check the executive because A, the executive is the party leader, and so the party faithful don't want to criticize the president. But B, if the people themselves want something and the president gives it, members of Congress are sometimes inclined not to criticize the president for acting to gratify the people's wishes. So I think Tanner is right that there is a sort of a change in our perception of what presidents can or should do, and that the checks on the presidency are weaker now than in the past. But there still is this check, right? I mean, if you can go to court, if you have standing, and it's not a political question, et cetera, the courts will rule in your favor, and you will be able to stop the executive, right? And so with respect to the assault weapons ban, I guarantee you someone who's subject to that will sue the executive branch and argue, A, the president doesn't have statutory authority for this, B, it's unconstitutional. And then it'll be up to the courts to decide this. And then it'll be up to you to decide, right, as a voter, whether you think the president was right or wrong when you vote next. Those two features still exist, right? The courts still check the president, and the people's perception of the Constitution does as well. Congress is unfortunately a weaker check.
And on the note of checking the president, I think we have one last question before we go ahead and wrap up, and this is for both speakers. First, for Professor Prakash. Do you think SCOTUS in its current configuration will more actively police presidential action?
That's an interesting question. I don't think either the liberals or the conservatives in the court are less inclined to check the presidency. They have different conceptions of the presidency, right? The originalists want to follow the original Constitution, and you've seen John and I disagree about those contours, but they have this methodology. The progressives are more apt to think that whatever practices we have today should be understood to be part of our lived Constitution, right? And you saw this in the case involving the recess appointments clause, where Breyer is basically pointing out a practice that is at great variance from the founding. So they both believe in constraints on the executive, but they have different conceptions of what those are and how they can change over time. I don't think either one believes the president should just prevail all the time. There were conservatives who voted against the presidency with respect to the Jerusalem embassy issue, the Zivotofsky case. And the progressives voted against Obama, right, in the recess appointments clause case, right? Even though they described presidential power broadly, Barack Obama lost. That was a 9-0 case. So I don't know if the conservatives on the court are more apt to check the Biden administration than the progressives. I think that they both have different theories and they both use it in different contexts.
Okay. Well, I think on that note, we're going to go ahead and wrap up. Thank you both so much for lending us your time and expertise and working with us through some technical difficulties. We really, really appreciate it. So thank you to everyone who came to listen to Professor Prakash and Professor Yu. This was our last event. So we will see you around next semester.
Thanks so much,
Thanks,
guys.
everybody. Sorry about the failure of California to have any working electrical power grid.